Okay, thanks everyone for joining us today for what promises to be a really excellent and informative webinar on third-hand smoke, what every legal professional needs to know. I see people are jumping in quickly. We have already over 90 participants here to listen, so we're going to go ahead and get started now. It is my pleasure to all welcome you. My name is Dr. Heather Whitfley, and I am associated with the Thirdhand Smoke Resource Center. And on behalf of the entire Thirdhand Smoke Resource Center, I want to welcome you to today's webinar. The center is part of the California Thirdhand Smoke Resource Consortium, which is funded by the Tobacco-Related Disease Research Program, TRDRP, here in California. The consortium is a multi-institutional and interdisciplinary collaborative involving research groups from Lawrence Berkeley National Laboratory, San Diego State University, the University of California, Riverside, the University of California, San Francisco, and the University of Southern California, where I'm located. The center also disseminates the consortium's translational research and third-hand smoke knowledge to stakeholders and to the public. And so we run many different events, including occasional webinars such as this one. We have a very active social media presence and a website that has tons of information available to you. If you're looking for more information on third-hand smoke, that's at www.thirdhandsmoke.org. So the learning objectives for today's webinar are to first discuss what third-hand smoke is, its origins, its constituents, its routes of exposure, the health and economic impacts, prevention measures, and how we can remediate third-hand smoke. And then we're going to go on to describe the legal analysis of residential property and consumer protection law, including disclosure requirements and industry standards and housing and building codes relevant to third-hand smoke exposure. Then we're going to have two really interesting legal case studies, one discussing family law and another looking at real estate transaction law. So it'll be a full 1.5 hours. We'll have our presentations followed by what we hope to be a really robust discussion session. We have a discussant with us as well today, who I'll be introducing in just a little bit. Here are our speaker disclosure statements showing that no one today on this webinar has any actual or potential conflict of interest in relation to this program or the presentation they're making. So our first speaker today is Dr. Jorg Matt. Dr. Matt is a professor of psychology in the College of Sciences at San Diego State University, and he's also the director of the Thirdhand Smoke Resource Center. His research focuses on human exposure to tobacco smoke toxicants in real-world field settings and on strategies to protect non-smokers from the exposure to tobacco smoke toxicants from secondhand and third-hand smoke. And Dr. Jorg will be talking to us today about what third-hand smoke is and why we should care. So Dr. Matt, I'm going to go ahead and turn over control of the webinar to you.
Thank you very much, Heather. Let me switch over to my presentation. Here we go. I think you can see my slide.
We actually can see your slide as well as everything else. So it's not in presenter mode right at the moment.
Okay, here we go.
Perfect, thank you.
All right, sorry for that. Okay, I will provide you with a very brief overview of about 20+ years of research on third-hand smoke to answer the following questions. What is it? How does one get exposed to it? How do we measure third-hand smoke? And then from our rather unique perspective here at the Thirdhand Smoke Resource Center, what are some of the policy, regulatory, and legal loopholes that we believe need to be addressed to better protect non-smokers from third-hand smoke exposure? Very briefly put, third-hand smoke is the name given to the chemical residue that's left behind by tobacco smoke. And although the chemical mixture is somewhat different. The same principles that I'll be talking about also apply to e-cigarettes as well as cannabis smoke. So I suspect that we have all seen or smelled third-hand smoke. We may not have known that it's third-hand smoke, but we all smelled or seen it, perhaps in a hotel room, in a rental car, when visiting friends, or standing next to a smoker in an elevator. I want to show you a few pictures to give you the right impression here. So here's a home that was vacated, and it housed some smokers, and you can see kind of the characteristic discoloration of the walls, and you can imagine that there was quite a bit of smoking that took place in this room. Here's some plates, perhaps from a thrift store. You can see the residue that had accumulated here from plates left in a cupboard where smoke found its way into. Here is what we have wiped off on the outside of some of these polluted surfaces. Now here's a couch that was in a smoker home. And of course, if you think of this couch, there are probably some parts that can be wiped off, but this third-hand smoke residue penetrates deep into the upholstery. And if we were to cut through the upholstery, we'd see a gradient of pollutants, higher concentrations at the outside, but it penetrates deep into the upholstery here. So very little can be wiped off in this case. Of course, it's not just upholstery, it's toys, it's blankets, it's pillows, it's mattresses, it's clothes. Of course, it also involves the smoker, him or herself, the smoker's clothes, but also skin and hair. It doesn't stop when it comes to art. This is what a dentist might see. And if you've been a smoker, or if you live with smokers, know smokers, of course, you've probably seen the discoloration that smokers have on their fingers. So how does this residue end up on these surfaces? So I want to give you a little illustration here. There's an apartment 605, and we have furnished. There's a baby, there's a cat, there are toys, there's furniture in there. It all starts with tobacco smoke being released, and what looks like this grayish cloud, uniform cloud, actually is a collection of literally thousands of chemical compounds in the form of gases, as well as respirable particles. Now, as secondhand smoke spreads throughout this indoor environment, it gets in contact with surfaces. Many of these compounds in secondhand smoke start depositing and adsorbing to these surfaces, such as carpets, tables, the baby, the cat, the toys, you name it. As smoking continues, this adsorption and deposition continues, and over time, weeks and months of smoking, these deposits create reservoirs. Some of these reservoirs we can see in discoloration, but as you can imagine, over months and years of smoking, there are considerable reservoirs that accumulate. I just want to give you one example of how much of these chemicals actually adsorb. Nicotine, for instance, has been studied extensively, and we know that about 80% of all of the nicotine in tobacco smoke ends up sorbing to surfaces, sorbing into walls, sorbing into upholstery, and remains local in an indoor environment. So as the smoking ends and perhaps a smoker quits or moves out, what remains behind are these reservoirs of these pollutants. Now, from these reservoirs, the re-emission starts, the off-gassing, and this is sometimes what we can smell, because these become, some of these are odorant gases that we can detect with our noses. As people move around, the dust that has deposited resuspends. Let's add to this some of the common oxidants that we find in the ambient air, like nitrous acids or ozone. Secondary reactions start such that this chemical residue begins to chemically age. There are novel pollutants that are being created. Some of these novel pollutants include carcinogens that were not present in freshly emitted tobacco smoke. So here's our definition of third-hand smoke. Third-hand smoke is this complex mixture that changes over time and has its origins in the secondhand smoke that's being emitted. It remains on surfaces, becomes embedded in objects, walls, floors, you name it. It can be re-emitted into the gas phase from these reservoirs. That's the off-gassing. It can be resuspended from these dust deposits that then can be inhaled again. And it reacts with oxidants and other compounds in the environment to yield secondary and tertiary pollutants. How do we get exposed to third-hand smoke? Well, inhalation is one important exposure route in that the off-gassing, the compounds that off-gas can be inhaled, which is the part that we can sometimes notice as stale tobacco odor. However, in addition to inhalation, there are two important additional exposure routes. And the first is ingestion. Ingestion of these certain smoke chemicals from polluted objects, such as plates, for instance, but also hand-to-mouth behavior and the ingestion of dust. The latter is particularly significant source of exposure in children. And then third exposure route is dermal transfer. Dermal transfer occurs when certain smoke polluted objects get in touch with the skin through clothes, through pillows, blankets, furniture, or when the re-emitted certain smoke pollutants in the air come in touch with the skin. What are some of the toxic constituents in certain smoke? And I'm not going to give you a chemistry lesson here, but I want to point out one important collection of these compounds. And these are compounds that are listed under California's Prop 65. So far, we have counted 25 carcinogens and reproductive toxicants that are listed under California's Prop 65. And I've highlighted here 3: nicotine, that's being collected in these reservoirs in large quantities, and that can react and form novel tertiary and secondary compounds. And then 2 tobacco-specific nitrosamines that are known carcinogens and play an important role in the measurement as well as in the health implications of third-hand smoke. And my second bullet here refers to a US Surgeon General report from 2006 that concluded that there is no risk-free level of exposure to tobacco smoke. And this includes secondhand smoke, and this also includes third-hand smoke, as many of these toxic compounds have their origins in secondhand smoke. How do we measure third-hand smoke? Well, the measurement focuses on the residue that's left behind on surfaces and in dust. The most common method involves wiping surfaces that are then, and these wipes are then measured and analyzed for nicotine concentration. It starts with a detailed protocol that involves a template, involves a cotton wipe where the 10 by 10 centimeter area is wiped. And then the wipes are analyzed for nicotine. Nicotine is important because it's specific to tobacco. It has no other source that could deposit in dust or on surfaces. And it is a marker for a collection of toxic compounds with very similar chemical properties. The template you see in the picture here, and it is wiped. We also collect a field blank so we can discount sources other than the surface when we do our analyses. The analysis is done in a chemistry lab using liquid chromatography, 10-dim mass spectrometry. We express the amount of nicotine in terms of micrograms of nicotine per square meter. And the method that we use here in our lab has a detection limit of 0.01 micrograms per square meter. So how much nicotine is there on surfaces? So if we were to live in 100% tobacco-free environments, we would expect that all of our measures would come out at levels below the limit of detection. In fact, however, when we examine homes in San Diego, only about 5% of homes have levels that are below the limit of detection, which is because after decades and decades of indoor smoking, and continued high levels of prevalence, there's a lot of tobacco smoke that is being generated on a regular basis. Now, if we look at non-smokers with long-term rigorous smoking bans, we typically find levels of about 2 micrograms per square meter. And in San Diego, there are about 60% of homes are at these levels. If we look at smoker homes with indoor smoking bans, the levels go to about 5 to 70. If we look at homes of smokers with indoor smoking, the levels go up typically above 30, all the way to the 3,000s or so. The highest levels that we've measured was in a casino that was about to go smoke-free, where we had levels of 100,000 micrograms per square meter. Now I'm going to add one more figure here, which is relevant to a case that will be later discussed, the LA condo, where a surface was wiped and the result were 42 micrograms per wipe in this 10 by 10 centimeter area. That corresponds to 4,200 micrograms per square meter. This is what we would call in the casino range. So what are some of the policy, legal, and regulatory loopholes that we encounter here at the Resource Center when we get calls and emails from people moving into homes or concerned about the health impacts? One area of loopholes is limited disclosure requirements of environmental hazards, especially in the context of real estate transactions. There are also loopholes and limits to current housing codes that do not specifically address issues of tobacco smoke residue. They address issues of mold and lead, but not necessarily, not housing and not tobacco smoke. There's also environmental impact. Imagine all the drywall and all the carpets and furniture that are highly polluted and that are being disposed of. This is to a large extent toxic hazardous waste, and very little regulation currently exists to address the impact. There are quite a few multi-unit housing buildings and other environments where smoking bans exist, but they're often poorly implemented, which leads to third-hand smoke pollution. And there are still indoor environments where smoking is allowed when non-smokers are not present. So for instance, in the transportation industry, it's quite common to share trucks, for instance. So one day, a smoker might drive in a truck and smoke, next day a non-smoker, and then of course that non-smoker is in a certain smoke polluted environment. There are also hospitality venues, smoker rooms where a non-smoker may end up staying overnight, rental cars as well. So here's where my talk ends. Thank you very much for your attention, and please do share your questions through question and answer buttons. Thank you very much.
Thank you, Dr. Matt. Just a couple technical issues administrative issues I wanted to mention really quick in response to some of the questions we've been receiving. The slides and the recording of this webinar will be made available. It will be posted on the Thirdhand Smoke Resource Center website. All registrants for the webinar will receive a link and news when this is posted, which hopefully will be in the next week or so. So all of this will be available for you moving forward. And then the second question I wanted to make was that please do post your questions in the Q&A forum of the webinar so that we can come back and address all the questions. We're going to have all our speakers go ahead and give their presentations and then open the floor for our general discussion. But please do at any point in time, post your questions in the Q&A so that we can be sure to answer them and come back around to them during our discussion. So it's my pleasure to introduce our next speaker, Jamie Long, who is a staff attorney with the Public Health Law Center, providing legal technical assistance on commercial tobacco control issues to public health professionals and organizations, legal professionals, and advocates throughout the United States. Previously, Mr. Long worked in Congress as a deputy chief of staff and a legislative aide, handling a wide range of policy areas and managing a congressional district office. He worked as a litigation associate for Morgan Lewis LLP and also serves as a Minnesota state representative. We're really lucky to get his time today to present to us. So thank you, Jamie, for coming along, and you now have control.
Thank you so much. I'll pull up my slides for everyone. All right. Great to be with everyone today, and thank you to the for the invitation to join you. So I will be talking about a few legal issues for third-hand smoke today. But first, just want to introduce ourselves a little bit. I'm here on behalf of the Law and Policy Partnership to End the Commercial Tobacco Epidemic, or the Partnership for short. And we're a joint initiative between the American Lung Association and the Public Health Law Center, where I work on contract with the state of California to provide legal technical assistance. And just a quick overview of what that is. We're able to help with legal research, with policy development, with publications, with trainings or presentations like this one, but we don't engage in direct representation of legal clients, and we don't lobby. So today I'm going to be focusing on a few consumer protection possible claims that individuals might be able to bring. And I think the overview that you all have shows why there might be some concerns from consumers about particular purchases that they might be making. So we'll be talking about implied warranties, about fraud-based claims, and about false advertising. There will be some statutes I'll be referring to, which will be California statutes. There are other states that have consumer protection laws, which are sometimes similar to the laws that are in California. But since I can't speak to all 50 states, we'll be focusing on the California laws today. So first, going to speak about implied warranties. So the law that I think will set up this conversation is California's Song-Beverly Consumer Warranty Act, which is sometimes called the Lemon Law for short. And this has an implied warranty attached to the sale of a used consumer good that includes an express warranty. So if there's any express warranty that is offered as a part of the sale, and there are also implied warranties that attach. And those implied warranties will extend at least the length of the express warranty, but under the law, it's no less than 30 days. So you at least have a month for the implied warranty and no more than 3 months. So this is applying to used consumer goods. Those could include things like cars, could include manufactured housing. It's really any manufactured good that is replaceable. And under the law, the options are that you could, if you're successful, repair the goods on site, have them picked up for repair or transported to a repair facility. So there are two implied warranties, and these, as I mentioned, also are often available in other consumer protection contexts, not just in the California law, but we'll talk about this one for today. So under the implied warranty of merchantability means that the good is fit for the ordinary purpose for which the goods are used. So this is can be a pretty high bar. For a car, for example, I'll be using a used car, I think, is the easy consumer good to understand some of these claims. You would likely have to show that you are interfering with the ability to provide transportation. So it's not a general concern about any health outcome that could happen in the vehicle. It would be the ordinary purpose for the goods are being used. So in this case, driving the car. So one example is a court found a car that had an offensive air conditioning smell, clanking brakes, faulty transmission, and white smoke coming out of the exhaust was not considered fit for its intended purpose. So if you were looking at this in the third-hand smoke context, you would have to show that the car was essentially not able to be driven because of the smell or the impact from third-hand smoke. The other type of claim for an implied warranty is implied warranty of fitness. And this is that the standard here is there's a reason to know that the buyer requires a good for a particular purpose and that the buyer is relying on the seller's skill or judgment in making the purchase. So the buyer would have to show, would likely have to, in this case, request a smoke-free car in the example of a car, and the seller would have to make a representation that the car was smoke-free and that it was being bought for this purpose. So these are the implied warranty type consumer protections that you might see. The second type of consumer protection claims are claims based on fraud. And fraud is going to be a claim you can find in any state. And there are some basic elements that you need to prove fraud. The first is a misrepresentation, and this could include deceptive concealment, so not disclosing something, knowledge of the falsity and an intent to defraud the purchaser. And then there has to be justifiable reliance on the part of the buyer and damage to the buyer. For example, under fraud, there was a California court that found fraud for a car seller when they represented the car was in perfect condition and had original parts, but later it found out that the car was actually irreparably damaged and the parts were not original. So for the used car context, the purchaser would have to show that there was an affirmative representation of a characteristic that the car was smoke-free when it was not, that the purchaser was harmed by this misrepresentation, and that they relied on it to buy the car. So that would be the type of fraud claim you might be able to bring. And then California also has the Consumers Legal Remedies Act, and this prohibits unfair methods of deceiving into a purchase or a lease. And those could include representing characteristics that a vehicle or good does not have, or representing a particular standard or quality. This could also cover an omission, and there's an obligation to disclose the fact if the seller has exclusive knowledge of that fact that the buyer doesn't know about, or if they actively conceal it from the buyer. So it's considered a material fact if a reasonable consumer would have acted differently had they known it. So an example here, going back to the vehicle hypothetical of a fraudulent omission, was a vehicle with windshields that were prone to crack. And they knew about that. They did not disclose it. That was considered material. So for example, if you were looking at a used car sale and they were using air fresheners to try to conceal the smell in the car, that could be relevant to this determination of whether or not they were making a fraudulent sale and attempting to cover up a third-hand smoke problem. A third type of claim in the consumer protection space is false advertising. So this would be fact specific, but under California's false advertising law, the unfair competition law, they prohibit unfair, deceptive, untrue, or misleading advertising. So the buyer would have to show that they suffered an injury as a result of the false advertising. And they also have to show that the advertising statements were ones on which a reasonable consumer would rely. So for the used car hypothetical, again, a buyer would have to show that a car was advertised as smoke-free, that they were injured by this false advertising, either with a loss of money or the use of their property, and that the advertisement was one on which a reasonable consumer would rely. So those, again, would be fact-specific determinations. And then I'll just touch on California's Proposition 65. And unlike the other three, where there are many other states that have different consumer protection laws or false advertising laws, Proposition 65 is pretty unique to California, but I think it provides an interesting example. So this is known as the Safe Drinking Water with Chemicals Known to Cause Cancer or Reproductive Toxicity Act. Is the full name, but people tend to call it Prop 65 because it's a little easier. So it applies to businesses with 10 or more employees, and they must provide a clear and reasonable warning before knowing exposure to chemicals that cause cancer, birth defects, or reproductive harm. Tobacco smoke and nicotine are both on the Proposition 65 list as known cancer-causing chemicals. So knowingly exposing tenants to nicotine or tobacco smoke would warrant a Proposition 65 warning unless the business can show that the anticipated exposure level would not pose a significant risk of cancer or reproductive harm. So if an apartment owner was aware of detectable levels of nicotine in third-hand smoke from a previous tenant's apartment, for example, under Prop 65, the business owner should warn prospective tenants. This could, though, come in the form of a lease. It would not necessarily need to be posted warning. So that's where I'll stop for today, but happy to answer questions on some of these issues or on other issues related to third-hand smoke and the law. And this is our contact information if you would like to reach out. Thank you so much.
Thank you so much, Jamie, for that great overview. And again, I'm seeing questions coming into the Q&A, so please do go ahead and keep asking your questions as they come up. And I encourage our panelists to also respond in text if they have some immediate responses to some of the questions coming up, and otherwise we'll return to some of these themes in our discussion. So we have two speakers for our next presentation. The first is Michael Fitzgerald. He is a senior partner at the law firm, Fitzgerald Cap Creditor LLP, located in Irvine, California. In 40 years plus practicing law, Mr. Fitzgerald has handled a variety of cases dealing with business disputes, real estate, and product liability. He's tried more than 100 jury and bench trials to verdict. A particular interest of Mr. Fitzgerald's is the prosecution and defense of environmental cases, including cases involving third-hand smoke issues. Recently, Mr. Fitzgerald was involved in representing a client who unknowingly purchased a residential property with third-hand smoke contamination, and we'll be sharing some of that experience with us today. And our second speaker is Natalie Foti, who is an associate at the law firm of Fitzgerald Yap Creditor LLP, located in Irvine as well. Mrs. Foti's practice is diverse and touches on a wide array of practice areas, including business torts, fraud, breach of fiduciary duty claims, trade secret theft, limited liability company disputes, and real estate matters. Ms. Foti's practice includes representing individuals and businesses, both large and small, in and outside of California. So I welcome them to give their presentation on third-hand smoke and the sale of real estate property.
My PowerPoint presentation.
You want to start first?
You go ahead.
Okay, I had to stop video or start.
You're on video.
I'm on video right now.
Yep.
Okay. Good morning. Yes, this is Mike Fitzgerald, and thank you for having me. I work with Dr. Matt on our particular matter or matters, and he was exceptional in terms of explaining to everyone that was involved in that case the science behind smoke inhalation in units that have been either abandoned or no longer active by the previous smoker. Our case was rather unusual, involved a $1 million condo downtown across the street from now called the Crypto Center. And it was the previous owner had unfortunately passed away. Though we were able to have a deposition of that owner, the owner was not available for any further examination or investigation. And of course, as typical in what we do, we're involved in the search for the truth. The previous owner denied having any, playing any role in smoking other than an occasional cigarette on the veranda of this beautiful condominium that I'm showing to you now. So what is one to do? Is one to, go to the security guard and find every person who visited the unit and depose as many people as they can to determine to what extent this person smoked beyond an occasional cigarette on the balcony? Well, that's not practical. And that's where Dr. Matt steps in and, as we'll report later, did a very exhaustive analysis along with the previous owner's boyfriend through a nicotine swab sample to determine, to take swab samples from very unique areas that would not be affected by any cleaning solutions. And those are areas that are collected in the reservoirs of the home, such as the top of doors. I don't think too many people, at least I don't, clean the top of your door sill, as well as ventilation ducts. In any event, you know, whether your house sells in a day or two or more than that, there's always a rush as a seller to try to get the highest possible price. And as a buyer, you're anxious to close the deal. And when a price is finally negotiated, as we probably all are aware of, you receive a mountain of paperwork. And if you're represented by a broker, and for the brokers out there, presumably you are helping and assisting the buyer in going through that paperwork. And paperwork typically has to be completed in a few days. And the paperwork is includes items, and I've just put up a seller property questionnaire. It includes items that was central to our case because the defense in this particular matter was simply, hey, we kind of told you. You should have figured it out, and it's your fault, not ours. Well, the form that I have before you is a California Association of Realtors form. And from a legislative standpoint, I'd like to see this form improve as the science grows with third-hand smoke. And it has elevated itself from the other category, other meaning anything not already mentioned, like a crow's nest or loud neighbors. That's not pre-printed on the form. But if you had a crow's nest or lived next door to a rock band, that's probably something that a buyer or a prospective buyer would probably want to know. And if I was counseling that buyer, I would certainly put that under the other portion of the disclosure. The disclosure, if I can I have the first page. The first page of this particular disclosure is purposeful in terms of to what extent a seller can find loopholes to avoid making full disclosure. And there's specific instructions on this California real estate form under item 3, where it says the purpose is to tell the buyer about known material or significant items affecting the value or desirability of the property, and to help eliminate misunderstandings as to the condition of the property. It goes on under Roman numeral 5, for each statement below, answer the question, are you seller aware of, by checking either yes or no. Explain any yes answers in the space provided or attach additional comments, and check section, I think it's 40. In any event, in this particular case, all items were marked no. And remarkably, the items that were marked yes, such as are there any industrial noises? Are there any parks going up? Is there any construction? Those were marked yes. And as instructed, the seller and their broker put in an explanation to provide a buyer with enough information that they can make an informed decision to inquire further. In this case, again, under the other, we made, this issue has made the print, and under item 2, it says any occupant of the property smoking on or in the property. And it's marked yes. And in this case, no explanation. Certainly, we'd want to know, does the buyer, is he or she a chain smoker? Do they smoke inside? Do they smoke outside? This particular owner, we learned through various sources, was amounted to be a chain smoker, though he denied it. And the evidence that was accumulated by Dr. Matt, as well as other evidence, supported the fact that this was a significant smoker that led to significant residue being collected on hard surfaces that was, after many attempts to eradicate it through cleaning agents, particularly with this particular buyer who was somewhat sensitive to smoke. The only option that they had was to actually partially demolish the unit to eliminate the reservoirs that was collecting these toxic gases, which, as you can imagine, is some expense. So you're probably all asking yourself, well, why didn't the buyer, when you come in there, we hear that there's odors and different things that are detectable, yellow walls. Why didn't this buyer notice it? Well, the buyer, when was captivated by the view and all the benefits of living in this high-rise community, it didn't have any odor. Why didn't it have any odor? Because when it was presented, all the windows were open and fans were brought in under the representation that was just to eliminate stale air from inside and outside the unit. So there was nothing that was detectable to any reasonable person. And this disclosure that was provided, in our view, was inadequate, misleading, and in our view, a partial disclosure could be, and in this case, worse than a non-disclosure. In any event, I'll turn this over to Natalie Foti in terms of providing a little bit more specifics about the testing and what we can do to protect future clients with respect to this issue. Thank you.
Thank you. So our client sees this seller property questionnaire and doesn't think anything of it because she's already been to the property 2 times during a walkthrough and doesn't detect any sort of odor because of the fan that's being used and because all the sliding glass doors and windows in the property are being open. So it's being well ventilated to mask the smell. And our client purchases the property, and the first day she's moving into it, she opens the door and she's immediately struck by a strong odor of tobacco smell. And in her case, not only was the odor itself a clear indicator of a third-hand smoke contamination, there was really a mountain of evidence that was really overwhelming. Mr. Fitzgerald touched upon the nicotine wipe samples that were done in the home by the client and her husband. And Dr. Matt testified in the case about some of the samples that were done by the client. And this is an example of one such sample. This was the laundry drawer upper track. And this came out to, it was a 10 centimeter by 10 centimeter sample size. So when you multiply that out, it's actually 4,200 micrograms per square meter. And that was consistent with levels found in casinos. Keep in mind, this was a new condo. It was no older than 9 years old. So that was just indicates how much smoking had transpired over a relatively short period of time. That's not an old property. And there's also a photo beneath the sample results. That's a card table our client found in one of the closets in the property. And those are actually cigarette burn marks. So we can imagine that the prior owner of the property set that card table in the living room and was smoking on it. And those are the cigarette marks. So now talking a little bit about some of the law. So in California, there is something that's known as a common law duty to disclose. And what that is where the seller knows of facts materially affecting the value or desirability of the property, which are known or accessible only to him, and also knows that such facts are not known to or within the reach of the diligent intention and observation of the buyer. The seller is under a duty to disclose them to the buyer. When the seller's real estate agent or broker is also aware of such facts, he or she is under the same duty of disclosure. So the common law duty of disclosure that applies to a seller of residential property, that same duty also applies to their agent if their agent is aware of that. In our case, we had facts to show that the seller's agent knew that the owner was a smoker and had smoked in the home, which is why the seller's agent had utilized a fan during open houses and walkthrough. It was to mask and conceal cigarette odor. And here, the purpose of the duty disclosure is to ensure that the buyers provided sufficient and accurate information to make an informed decision about whether to purchase. And the Third Hand Resource Center, I know, recently conducted a poll of California residents, I think about 1,800 residents, and 96% of California residents believe that they should be informed if they are purchasing a home or renting a home about whether it may contain toxic tobacco smoke residue. And what could be more important about that than to know whether the surfaces of your property, the home that you're living in, contains potentially polluted information. And one of the issues in our case was whether the seller property questionnaire, whether the seller in marking the yes box in response to the question about whether any smoking had transpired on the property, whether that satisfied the common law duty to disclose, whether the seller in just merely checking that box had satisfied his duty. And our contention in that case was certainly no, because at best it amounted to a partial disclosure, that once a seller speaks about a topic, you have to provide all the facts to bring context to that answer. Because without it, a buyer doesn't know if it was 1 or 2 cigarettes across 9 years, or whether it was thousands of cigarettes over the course of 9 years. So it's really important that if a seller speaks up, they have to say everything they know about the topic. In this case, they didn't. They concealed that, and there's a financial motive to conceal it because it's common knowledge and that homes of smokers don't fetch as high as a price as a non-smoking home. I think that's pretty obvious there. And so, in just conclusion, third-hand smoke is really an issue that the law is catching up to, where there's no known California appellate cases that discuss the topic of third-hand smoke. Third-hand smoke, with the popularity of e-cigarettes and vaping, it is not going anywhere. And it's really shocking how much e-cigarettes and vaping you see going on, especially now in the younger populations. And I think we can assume that the younger generations are going to be doing that inside their homes. So it's important to remain vigilant of this issue and that there be public awareness about third-hand smoking. Thank you.
Thank you so much. All right, and then we have one more speaker before we begin our discussion. And so last but certainly not least is Robert Winterton, who graduated with a Bachelor of Arts degree from George Wythe University in 2011. In 2018, he graduated with a Juris Doctorate from the University of Iowa, and he was admitted to practice law that same year in both Iowa and Utah. From 2018 to 2022, he worked with the law firm Elwood Donahue, Brown, and White in Northeast Iowa, where he represented clients in litigation. Since 2001, he has worked with the law firm of Kyler, Kohler, Ostermiller, and Sorensen in Southern Utah, where he advises clients on business planning, estate planning, taxes, and self-directing retirement plans. And he will be giving us another case study today regarding recent litigation. Thank you, Robert. You have control.
All right, thanks. So that slide should have said 2000. Since 2021, I've worked where I'm at now. Anyway, so I went to law school in Iowa, and I was born and raised in Utah. So I'm admitted to practice law in Iowa, where I stayed after law school and litigated cases, criminal cases, family law cases, divorces, custody. I litigated contract disputes, torts, and other issues, what would come in the door. And I worked in a small rural practice where we did everything pretty much, I guess. So anyway, whatever came in the door. And the way I got involved in this topic of third-hand smoke is a mother. Let me share my screen here. Share. A mother approached me, came in the office, and she'd been served papers. How any lawsuit starts is, father filed a petition for visitation with his son, and the mother, and then served the papers on the mother. So the mother comes to me. She hadn't really seen this guy since the baby was born, or since even before. He hadn't seen his son, and they lived in close proximity. But anyway, no, never any support or any of that. But the problem, and this is the concern, is this little boy, almost 4 years old now. He'd had a heart transplant before he was 1 year old, and so because of the heart transplant, he had to take medication that would suppress his immune system to prevent his body from rejecting his heart. And because of that, he had that immunocompromised condition that he couldn't be around smoke, secondhand smoke. The cardiologist never mentioned third-hand smoke, but just gave a list of things, he needed to be protected from. And she was concerned because the father, as she knew, was a chain smoker, and he'd been smoking pretty much since he was in his mid-teens, and he was addicted to it. And he couldn't stop, and he smoked everywhere. He smoked in his house. He didn't go outside to smoke. And not that you don't bring it in anyway, but it makes it even worse when he's smoking in a small, and he lived in a small single wide trailer that was, anyway, and he'd been in there, I think at least it was 10 years. But, and so those are basically the facts that you need to know is kind of listed on this slide, which you'll get copies of. But the issue is, now this father is petitioning for normal visitation, every other weekend, Wednesday evenings. But the idea is he's going to take his son to his home, where that's where the son's going to stay the night over every other weekend. And the question is, should he be given unsupervised overnight visitation in his home when he lives in a small single wide trailer that's been extensively smoked in for 10 plus years? So let's talk about family law cases. And this might be, maybe a lot of you aren't here for this, but y'all know somebody who probably smokes and has kids, or they're married to somebody who smokes. And so we're going to talk about a custody dispute, where in a custody case, it's always about what's in the best interest of the child. That's the court's governing consideration in a custody case. So there's a couple things here to note. Pursuant to the Due Process Clause of the 14th Amendment, parents have a fundamental right to make decisions concerning the care, custody, and control of their kids. This is under the assumption that, parents will act in the best interest of their child. If it's shown that they're unfit, or that the parent's activity will harm the child, then the court has discretion to restrict a parent's constitutional right and place conditions or restrictions on the parent's visitation rights, in this case, or custody, when it's in that child's best interests. So there was a question in the comment I noticed, something about is there a right for disabled people to have the right to smoke? I'll just say that the US Constitution, nor any state constitution I know of here in the United States, I don't know any law that provides a parent with a right to smoke. Okay, so anyway, there's just nothing laid out. But I think one can make the claim that a child has a right to live in a smoke-free environment. And I cited this in a trial brief to the court, because you argue what you can. So anyway, I cited the Article 25 of the UN Declaration of Human Rights. Here's the quoted text is on this slide. Basically says everyone has the right to a standard of living adequate for the health and well-being of himself and of his family. So I think under that, you could argue a child does have a right to live in a smoke-free environment. Now, so what are the challenges in a custody case? First off, I'll just say really quick, a court is generally they want to do just normal visitation. They want to just put it on there and have it on, automatic drive, every other weekend the parent gets the child, as long as there's no issues. And so anyway, the next slide we're going to move to is talking about some of the challenges that are going to arise from litigating custody. So first off, out of sight, out of mind. Don't see it. You don't think about it. You don't really maybe believe it's there. And so you got to help the court understand that out of sight shouldn't be out of mind. I think that might be helpful in given COVID, germs, all this, it can harm you. What you can't see can harm you. The second challenge is that the belief that visible or invisible, I should say, third-hand smoke is not near as deadly as second-hand smoke. So we've and Professor or Dr. Matt spoke earlier about how actually third-hand smoke has some new novel carcinogens in them that's not present in second-hand smoke. So because third-hand smoke undergoes a chemical aging process, and when it mixes, anyway, I'm not a scientist, but as I understand it, creates secondary reactions that then produce things that are actually toxins that are actually more, toxic that are not in secondhand smoke. The third one, this is a big deal. There's a belief that it can be removed. The third-hand smoke, you can just do a deep clean, and get it out of the air, so that you're not exposed to it. But as Dr. Matt explained, this is a delusion. When it gets into the materials, they become a reservoir that then once the smoking stops, it's going to start emitting. You can wipe down everything, get rid of the dust, and that will create a temporary reduction in the third-hand smoke levels. But after a period of, a few months, it goes back up to what it was before the deep clean. And so, speaking of the case that I litigated, when I called Dr. Matt to testify as an expert witness in this case, but ultimately took the court several months. I think it was before we got a disposition in the matter. I think the court was trying to come to either he didn't believe that a professional deep clean that it wasn't good enough to protect against third-hand smoke, or he was trying to find some compromise to not restrict the parents' rights. Like I said, the court wants to just keep it the normal way with visitation. And ultimately, the court determined the father should have normal visitation, but only after, he said, a reputable company performs a deep clean of the father's home, which consisted of shampooing, carpets, furniture, cleaning or painting of the walls and ceilings. And then he also said it had to have a reputable company detail the father's car that's used to transport the child. And after that, then he can proceed with normal visitation. So next, there's a couple more challenges. I think that the absence, I'll just read it from the slide, but the absence of a reliable hard data test of third-hand smoke levels in a parent's home. So a father testifies like, yeah, I smoke a pack a day. Yeah, I don't always go outside to smoke. I sometimes go out on the deck. Sometimes I smoke in my house. I smoke in my car, sure. But how long you been smoking? Oh, since I've lived there. How long have you lived there? 7 years. We still don't know exactly, well, how much third-hand smoke is in this parent's home. So the absence of a reliable hard data test of the third-hand smoke level is going to be an obstacle. So what's the goal? We need to obtain a reliable hard data test of third-hand smoke levels in a parent's home. And it should be obtained before trial. This is likely, anyway, I was thinking about how you would do this. I know there's probably not a lot of attorneys here, but I hope you guys will share this if you know somebody who's going through a custody dispute and the other party smokes in their house and this is an issue, they'll hope that you'll direct them to these slides and maybe this video, send them my contact information. But ultimately, in Iowa and also in Utah, you can submit an affidavit on a motion. And I think before court, you'd need to file a motion, a request to the judge, asking the judge to order that there be a test done, that this is a factor that's going to be a relevant issue in the case. And that there needs to be this test, and you could submit an affidavit with like Dr. Matt's testimony regarding third-hand smoke. And I think that's probably how you'd get it, but you need to get it before trial. And so what are some ways to test the third-hand smoke levels in a parent's home? A test kit and a wristband were a couple things that were talked about at the custody trial that I had. So these are some of the questions, the issues you're gonna have to work through a litigator who's litigating in a case like this. Who would collect the samples if there was a test kit? How can we guarantee the instructions are followed? And this was a question I know that I saw in the comment also, is how do we do this? There's a wristband that it's easy to implement, but then you got to make sure that's not messed with. You put the wristband in the home anyway, and you can learn more from the Third Hand Smoke Resource Center on that. So how do you get past these challenges? Well, you're going to need expert witnesses that can provide expert testimony, offer opinions that are sufficiently grounded in reliable scientific methods. Moving on, here's some of the issues that you're going to need an expert witness that can testify to answer these questions. So I had Dr. Matt testify, asked him to testify. He graciously did so, and at this trial. So these are some of the, like I said, what is it? We've talked about that here today. Does third-hand smoke become more toxic with passage of time? Again, getting past all these obstacles. I'm not sure what am I on time here. I don't need to go through all the questions, but well, maybe I think I have time to do that. Let me just go through how toxic is third-hand smoke as compared to second-hand smoke. How long does third-hand smoke persist after the occupants have stopped smoking in the home? That was something that the judge wanted to know. Like, well, let's say he just quits, let's just say he stops smoking in the home. Well, that's going to have to be addressed. Can we fully detect the presence of third-hand smoke? Again, it's out of sight, out of mind. You want to talk about that? What can be done to detect the presence of third-hand smoke? How are people exposed to this? And Professor Matt talked about that. Inhalation, ingestion, dermal transfer, and children are more exposed to that, as we know. Anyway, will a professional deep clean permanently remove it? Will a layer of paint on the wall seal in whatever is in the wall board behind the layer of paint? And ultimately, the expert in my trial, Dr. Matt, he testified, you can put a layer of paint on there, but the particles in third-hand smoke are so fine, they go through all the cracks and everything. You think that paint sealing it in, it's not at all, not even close. And what is required to permanently remove it from the home? It's going to be just gut it. What is required to prevent third-hand smoke from re-entering the home? So you're also, if in a custody case, it's not just, okay, we've established that this is terrible. Third-hand smoke's terrible. We've established that there is third-hand smoke in this parent's home. Okay, how's that going to affect the child? So you need an expert witness to testify to that. Is it toxic to humans? What's the risk of harm of these toxins? What are the health risks of a child's exposure to third-hand smoke? What are the critical factors that will affect this risk? For example, in my case, this child had an immunocompromise, because of his heart transplant. If he got it, he could easily get sick, an infection, and then cause his body to reject his heart, and it would kill him. So those are factors. Are children at greater risk of exposure to third-hand smoke than adults? Why? And so you'd want someone to testify that a child, being closer to the ground, closer to the dust, they put everything in their mouths. And so all the various reasons why they're at much greater risk. And these are the questions, that an attorney would ask an expert witness on the stand. Again, we're just wanting to get all this evidence out in front of the judge so that the judge can use this as a factor for consideration in determining what the best interest of the child is. So we got to make it easy on the judge, and that's this is new to him. He's or her, this is new to the judge. What do I do? How do I put this into my order? We want to spoon feed it to the judge. we want to give the judge some proposed propositions to put in his order. So here's 7 of them. There could be more. These were 7 that were discussed at the custody trial that I litigated. So 1, never smoke inside the home, never smoke inside the car. Going forward, this is assuming that the third hand smoke's there. Wash hands frequently, especially immediately after smoking. If the parents smoked before entering the home, then they got to remove their clothes or put their clothes out of the home. You got to wash their skin, their hair to keep dust as low as possible. Get a HEPA filter vacuum cleaner, vacuum the entire home at least once every day, is keep that dust down. Refrain from smoking the day before a visit with the child, and on all days the child has contact with the child, and wear freshly washed clothes and shower immediately before meeting with the child. These are a few things. Obviously, it's not going to, these things aren't removing third-hand smoke from the home, but to prevent the environment from becoming like recontaminated. What's the gaps right now? Where are we at with this? I guess I call this state of the law right now. We're not so far yet, but a judge is likely to prevent a normal, healthy child from living in an environment that contains third-hand smoke. I think that's pretty clear. But so what's the next step to get there? I would say, look at children with respiratory problems or other conditions, like I said, that can cause a child to be immunocompromised so that they're not exposed to third-hand smoke. And this is a question that needs to be answered. At what point, and this is why you have an expert, the expert witness testifies how this third-hand smoke affects the child, but at what point do the health risks of third-hand smoke exposure to a child with respiratory problems outweigh the desirability of not precluding visitation from occurring in a parent's home or car? Like I said, again, a judge is going to want to just stick with the normal routine visitation. So at what point should we put some restrictions on that and say, you can have a visitation, but it can't be at your house. You can go stay at your parent's house. In this case, his parents were chain smokers. That's how it happens a lot of times. So his parents were chain smokers. Go to a hotel during your every other weekend. But anyway, so the opportunity here, though, in family law cases is we have an opportunity here to make case law holding that third-hand smoke is an unacceptable health risk to more children. The law moves slowly. It's extremely conservative. It's kind of the last to catch up to society sometimes, but we can make, if we keep putting this in front of the court as a factor for consideration, then courts are going to become more aware of it. It's going to get more into a case law. We can cite more laws. So what happened, by the way, in our case, we appealed the matter, and then the father didn't want to go through an appeal. He was just done litigating this. And so I'll just leave it at the parties negotiated and came to an outcome that was, acceptable to my client. So it didn't go, and that kind of, is good for the client, but we don't. I kind of feel bad that we didn't get to take it to a higher court where we can get, some case law out of that. So I just want to, as encouragement, courts were formerly not aware of the health risk posed by secondhand smoke. I remember the courthouse where this case was located, people used to smoke in the courthouse, I was told, in the 1980s, but somewhere in the mid 1980s, they banned all secondhand smoke, no more smoking in the building. So, over time, where secondhand smoke was totally acceptable, now it's not. And I think we can get there also with third-hand smoke. So attorneys just need to keep raising this issue as a factor, like I said, for consideration in custody visitation cases. And here's some cases they can cite before, to bring this to the attention of the court before a trial. File a brief, put the court on notice that, they're not the only one that's heard this. There's other cases in the country. There's not a lot, but hopefully we'll get more. There's a case in Louisiana where the court limited a parent's visitation rights when the effects of a parent's smoking were detrimental to the child's health. And that was in 1989. But there hasn't been a lot since then. So I think we just need to keep bringing this up. There's a case in New York where the court ordered parents to maintain a smoke-free environment for a child at all times in the home, the car, other indoor situations, and wherever possible and practical in all their circumstances, even when the child is not physically present during the time of any smoking incidents. And in this case, even when the child has no underlying diagnosis such as allergies or asthma. This was and you might see from the title of the case, MD, it was actually two doctors, they were getting divorced. And so this was a very topic in this divorce for determining custody. And then this last case, this was an Iowa case where the court terminated a mother's parental rights after considering how the mother trivialized her child's health problems and did not quit smoking after being informed the child could not be exposed to third-hand smoke. So not just secondhand, but third-hand. And so that's, what I hope you guys will share this slide with attorneys or if you know somebody that's getting divorced, they're married to somebody who's a chain smoker, they smoke in their house, their kids have respiratory problems. This should be a factor for consideration. Share this with them, have them reach out to me. Here's my contact information, and you'll have access to these slides. So I hope this is helpful. This ends my presentation. Thanks.
Thank you so much, Robert. That was fascinating. So much real world experience there being shared by both our last two presentations. And I'm excited now to welcome Cynthia Hallett, our discussant today, to help us lead through a number of really exceptional questions that have been asked in our Q&A and general themes and topics that have emerged from our presentations. So it's my pleasure to have Cynthia join us. Cynthia is president and CEO of Americans for Non-Smokers' Rights Foundation, which is a 501c3 established in 1984 to promote smoke-free indoor air. Cynthia has worked on numerous smoke-free air campaigns to protect all smokers, including musicians, casino workers, college campus faculty and staff, and multi-unit housing residents from secondhand tobacco smoke and third-hand tobacco smoke, as well as cannabis smoke and secondhand aerosol. And there's been some questions about cannabis in our Q&A, which I'm sure she can help us to address. She's co-authored articles on smoke-free trends and health equity protections, college campus policy trends, and the threat of legalized marijuana to smoke-free indoor air protections. She has a master's in public health from UCLA, and has worked at the National Center, at the National Cancer Institute, and at the Los Angeles County Department of Public Health. So welcome, Cynthia. I'm going to go ahead and stop my share, and I ask all our panelists to go ahead and turn on their videos so that we can have an in-person conversation.
Great. Thanks so much, Heather. And thanks to all of the presenters. This has been a fantastic webinar. There's always time and place to learn more. As Heather said, I am with the American Non-Smokers' Rights Foundation, and I will be dropping in a couple of links into the chat. We have the list of cities that have smoke-free multi-unit housing laws. Not all are comprehensive 100% for all of the units, but you can certainly see the progression over time. And right now there's 67 California cities that have some sort of law, but we do know that there are other cities across the US that are also interested in looking at adopting these laws. And just as a public health advocate, not a lawyer, but as an advocate, it's really critical for us to have the research information, both in terms of adopting these laws and then also for these legal cases. I saw that in the chat, one of the first questions that I think we could address is really looking at, are there any health effects on non-smokers to exposure to the third-hand smoke? So Heather, I don't know, I think I saw that you were going to maybe answer that question live. Do you want to take that one, or?
I think they'll go ahead and send that over to Dr. Matt to explain what some of the health effects of third-hand smoke are, both on young children as well as adults.
Thank you. That is an important question, and I'm going to answer it in multiple parts. So one line of evidence about health effects just comes from the fact that we understand what the constituents are of third-hand smoke. So knowing that there are carcinogens, reproductive toxicants, various irritants, ultrafine particles, we know that exposure to these compounds, depending on dosage levels and duration, will cause ill outcomes. So that's one line of research. Then there's a line of research that's conducted by the Third and Smoke Research Consortium, where we have animal studies as well as human exposure studies and examine the short-term impacts as well as the longer-term impacts of this mixture of compounds. And then there's ongoing research with colleagues at Cincinnati Children's Hospital that examines the impact of third smoke exposure in young children. So from all of this research, some of it has been completed, some of it is in progress. All of the evidence points to health outcomes and health effects that are similar to those of exposure to secondhand smoke.
Great, thank you, Dr. Matt. And there were questions in the chat about whether or not there was any analysis looking at nicotine levels in recently built homes that had been inhabited by only non-smokers. I guess in some ways, like establishing a baseline level of, clean air.
Yeah.
Do you want to tackle that too?
Sure. If you remember my slide that had these color lines and boxes, this was actually based on research that we've conducted over the last 15 years here in San Diego, where we've examined in the most recent study 220 or so low-income homes in multi-unit housing. 90% of those were non-smoker homes. And so this is where this reference level is coming from, of about kind of a median level of about 2 micrograms per square meter in a typical non-smoker multi-unit housing unit. However, these levels can go up to several thousand, depending on if the current non-smoker perhaps was a smoker until 5 years ago, or just recently moved in and the previous unit was home to a smoker. So for us, we have kind of an internal reference level of about 2 micrograms per square meter is not uncommon in non-smoker homes because of the history that an apartment may have, because of poorly implemented smoking bans, you name it.
Great. Sorry, looking at 2 screens at once. There were questions about disclosures, and I think specifically the other disclosures, and wondering, I guess the question here is, would the other disclosure require the seller notifying the buyer about secondhand smoke from the neighboring unit in a condominium?
Okay, I'll tackle that. That's a really interesting question. The current, I looked over the CAR seller property questionnaire on that particular issue. And there's 2 areas that if I was a seller with a history of smoking and or a real estate agent representing the seller, there are 2 areas that call to mind where that should be disclosed. One is material facts or defects affecting the property not otherwise disclosed to the buyer. And if you have particularly if you have there's a condominium next door to you and you share a common wall, particularly if you're sharing the same HVAC duct system, and you have been exposed to odors from time to time, or when the doors open in the hallway with the draft comes into your home, I think absolutely in that instance, in that unique situation, one should disclose it. The other is there's another item on the CAR form that references neighborhood noise, nuisance, including odor. So if there's an odor coming from the neighborhood, that should be disclosed. And remember, there is that famous other category where there's no description. However, if you just know someone down the street or in a unit where there's no common wall, where there is no common wall, and from time to time people smoke there, and you don't have any odor in your room, in your house, or in areas immediately outside, I think that would be highly debatable whether that should need to be disclosed. But as one broker told me, when in doubt, be transparent and disclose. It's so easy to do that. So thank you.
Right. And sort of I guess a similar question is, who would we be working with to try to change the limited disclosures? I think someone earlier talked about limited disclosures.
I'll take that question. Can you mute your mic? Can you hear me? I would, these disclosure forms are all prepared.
Oh, just lost you.
These disclosures. Sorry. So these disclosures are all done by the California Association of Realtors. They're the trade body that generates all of these forms. They kind of create the standard of care for real estate brokers and agents in California.
Let me add something to this, because in California, there's also an involvement of the Cal EPA that publishes a booklet about environmental hazards that need to be disclosed. So I think there are some other regulatory mechanisms where I think we could get better and more complete disclosure, specifically about specific sources.
Great, thank you. There's a series of questions looking or asking about the adoption of either a law at the municipal level or even getting like an HOA to consider adopting policies around smoke-free multi-unit housing. And I'm happy to jump in on that one. That's certainly something that we as an organization have been working on for the last almost 40 years. I think in addition to getting phone calls from people who work in restaurants and bars, that those people who live in apartments call us most frequently asking for assistance. We do have a lot of materials online to help organize that kind of campaign, but really it's very similar to organizing a campaign for a smoke-free workplace law, finding people with a common interest. For those in a condo and when you're working with your HOA, trying to put it on the HOA agenda. Maybe prior to doing that, you can consult with some of your other neighbors and do a survey and just asking if people are exposed and if they'd be interested in trying to pursue a smoke-free policy for all of the units. Considering that, tobacco use or tobacco is highly addictive, how do you then negotiate where you might allow people to smoke in some outdoor area where the smoke won't drift in? So all of these sort of items and tips we do have on fact sheets on that no-smoke.org website. And if you have other questions, feel free to contact me and I will put you in touch with Liz Williams, who is our expert on smoke-free multi-unit housing. And just quickly regarding, oh, sorry, go ahead.
Could I jump in on that too, Cynthia?
Yeah.
Just wanted to note that in addition to the great organizing support that A&R has, if folks are looking for legal technical assistance on smoke-free multi-unit housing, the Public Health Law Center has model ordinances that we've prepared for some states and are also happy to work with you on your particular state or tribal jurisdiction as well to work on a smoke-free multi-unit housing draft ordinance.
Yes, thank you, Jamie. We work with the fine lawyers at the Public Health Law Center very frequently on all of our different policy issues. So thank you for that. Just very quickly addressing cannabis. For us, smoke is smoke. And I'm sure that soon, we will also find out that the third-hand smoke from cannabis and marijuana is very similar. There may be differences, but there are similarities between both tobacco and cannabis or marijuana smoke. And so we know that they both create indoor air pollution, that some are more sticky than others. So you're going to have that on surfaces. And again, we have materials on how to start to include when we're talking about what products can be smoked, indoors or shouldn't be smoked indoors. It's tobacco, it's cigars, it's cannabis, etc. It's all of the vaporized products and so on. So whether it's the Public Health Law Center models or our own definitions, we can provide that information to you. And it is true that, we've come a long way in terms of identifying tobacco industry interference. And in some ways, we're seeing a resurrection of similar tactics from cannabis proponents. So for what it's worth, we do have some experience with that, and we can try to help you negotiate some of those. So there were questions about doing some testing. One is whether or not the wipe kit that is from the Thirdhand Smoke Resource Center is available. Sorry, there are more questions. You guys are so good. And then also a question about, isn't there a disincentive for apartment manager or owner to measure the level? And sort of how do we grapple with that?
Let me try to answer this. Yes, so at the Resource Center, we're conducting a pilot study where we have developed a do-it-yourself sampling kit that we work with individuals and groups to use these kits to measure third-hand smoke in homes or businesses. And in order to participate in this pilot study, contact me or contact us at contact@thirdhandsmoke.org. Are there disincentives? And the answer is yes, there can be, because once you've detected a level, there is kind of an implication of you need to do something about it. So there's definitely a positive side to it, in that if you maintain a smoke-free indoor environment, it would be good for an apartment manager to be able to document that this apartment or this building is indeed smoke-free and continues to be smoke-free. But once you measure something and it turns out to be high, then it's up to you to figure out what to do with it. So there is a disincentive, but just from an ethical perspective and from a business perspective, it would be good to exactly do this, to address the issue, to find the origins, and to put in place remediation actions to eliminate this particular source.
Great. Heather, how are we doing on time?
Yeah, we have only about 2 minutes left. Maybe one more question that we could address in the list. I know there was a handful of questions that were asking about people who may be exposed, like house painters, cleaners, other groups. Is there any kind of legal precedent or occupational health standards that can be used to address these issues?
I'm not quite following the question. Is this, would painters or crafts people working in a home be exposed to third-hand smoke as they visit there?
Yeah.
Well, more the legal implications of like worker health and safety.
Yeah.
And so, you know, if you go into this environment where you know smoking has been and there's third-hand smoke residue, you know, you would be talking about the residents and potential legal cases, but what about workers, construction workers, people who have to go into those homes, whether it's to remodel in general or perhaps to clean those environments? The brain teaser for our lawyers.
We've definitely been contacted by people in these situations. There was a nurse who had home visits and had to visit homes where people smoked, or they may not have smoked when she visited, but they were definitely exposed to it. And then there are lots of examples of indoor environments that are shared with non-smokers, especially workplaces. I think those are loopholes that need to be closed through probably legislative action.
Great. Well, we've had a really full hour-and-a-half presentation and discussion. We had lots of really great questions, not all of which have we been able to get to right now, but we'll go ahead. We have these recorded, and when we respond and send out the information from this webinar, including the slides and a link to the full recording, we'll go ahead and make sure that our experts respond to these remaining questions as well. We wanted to be sure to leave you with just a few additional resources, including the smoke-free multi-unit housing model ordinance, a resource kit, multi-unit housing and third-hand smoke resource, and a do-it-yourself testing and referral contact. Again, that's contact@thirdhandsmoke.org. If you'd like to participate, go ahead and reach out to us at the center. We'll also be sending you a link to complete our webinar evaluation, and we hope that you will do so and complete that evaluation so that we can improve on our webinars moving forward. Finally, I just want to thank again all of our speakers for joining us today, the Thirdhand Smoke Resource Center staff for all the work they put into organizing these events and all the other resources available through the center, the Thirdhand Smoke Resource Consortium researchers who power all of this information, the Tobacco-Related Disease Research Program for funding this work, and of course, all of you who joined today. We at times had over 120 participants. It's really exciting to see that level of engagement in what is just still an emerging issue. Be sure to follow us on our social media accounts and on our website, and we look forward to hearing from you. Reach out to us if we can be of any assistance in your future work. So thank you, speakers, again. Thank you, participants, and we'll talk to you soon.